So we have to be really clear here, Josh, that the judge instructed the jury that they can't use this evidence of abuse to say that the defendant has a propensity for violence and therefore he must have killed the victim in this case, or the victims in this case. No, what it does is establish some sort of MO. It establishes a motive. It tells a fuller picture of the story. What did you take away from this?
I'm so glad you brought that up because that is such a thin line to ask the jurors to walk, right? And I understand it. It's done all the time. It's an instruction that the judges give. Listen, you can use this evidence only for certain purposes, but you can't use it to show that he has propensity to have committed violence, and therefore he did commit the violence that he's accused of in this case. Get it. I understand it. There's case law to support giving that instruction. But how can you ask jurors who have no legal background to play those kind of mental gymnastics when they're listening to this testimony and be able to separate it as much as they have? I really don't think it's going to cause a problem on appeal because there is case law and the instruction is valid. But it's difficult for jurors to perform that function and be able to say, well, I'm only considering it for motive. I'm not considering it to say that this guy is a systematic abuser of women or of this woman in particular and must have committed violence against her. It's powerful evidence. I think it's probably the most powerful evidence the jury has heard so far.